So today's webinar is a special webinar dedicated and directed towards two communities, right? It's not a general open webinar, it's a two community webinar. The community of Indian Financial Forum, being led by Mr. Abhishek Varshney. And then, Sarish has been the helping hand there for making sure that the digital DPDPA group is doing well. And then with Tsaaro Consulting, right? We are consultants in privacy and we help out organizations, you name them and we are working with them, right? So those are the type of work that we do in terms of solving the problem of DPA. So what we want to do today is we want to let you know an approach and a solution to the Indian thought process of the privacy law. And yeah, and just so about us, we are around 150 people today. In 3 years, we're the fastest growing privacy consulting practice in India. We ourselves are ISO 27701. We preach and we do consulting for likes of Airtel, Vodafone. When I say I say Vodafone in Flipkart, Myntra. We work with most of them today. And you can just check out Tsaaro.com to know about all of our clients. And then moving on, we have Indian Financial Forum. So Indian Financial Forum is a financial community which connects industry leaders and helps you build your community and build your knowledge. So I am part of it. I'm loving it. And I think Sandeep is also part of it. And a lot of people in the session are part of the financial community. Hi, guys. This is Akash Singh from the community. Also, the disclaimer for the session is not a legal advice. A bit about our amazing panelists. I'm the chief privacy officer, the founder here at Tsaaro Consulting. Have been 7 years into privacy. I used to work with KPMG and then started Tsaaro Consulting and Tsaaro Academy 3 years back, and here we are, right? So if you search DPDPA online, you will probably be going through some part of Tsaaro Consulting, right, getting some knowledge. And again, the session is directed today again for the same reason. We have Sandeep G is an associate at Novo Juris Legal, right? He comes from a legal background, is helping out organizations do their DPDPA compliance. Sandeep, would you also like to introduce yourself?
Yeah, thank you for that, Akash. So I was into a SaaS-based company into data protection practice as a lawyer. I've been handling a lot of privacy contracts, helping them with compliance, privacy-related compliance, helping them with creating DPIA, data protection impact assessments, and resolving all other queries, privacy concerns from both internal and external stakeholders. And also, it's not just with respect to Indian for centric laws. I have experience working with a lot of clients across the globe, from US to Europe, with GDPR functions. So yeah.
And Ankit, he's right now an information security compliance lead at Pine Labs, but an amazing guy, knows privacy in and out, has been doing privacy compliance in KPMG, and then he moved to PwC, did an amazing job there. And here he is at Pine Labs. Ankit would like to introduce yourself as well.
Thanks, Akash. And I reciprocate the same that I have been working with Akash since KPMG days. And it's been an amazing journey so far. For myself, I am Ankit and I'm part of information security team within Pine Labs. I predominantly deal with the compliances, regulatory compliances, be it RBI, be it information security related requirements, be it data privacy. And I've been working on data privacy since the inception of GDPR since 2015. So it's almost 7 years now, 7, 8 years dedicatedly on privacy. I've worked on multiple regulations, starting from GDPR, then to Singapore, Southeast Asia, Malaysia, Dubai, Abu Dhabi, and then I'm very happy to see that we have something where in India and people are talking about it, and Tsaaro organizing these webinars to evangelize more and more people about the act and solving their problems. So it's good to be part of it, and I'm hoping to contribute and learn myself a bit from this particular webinar as well.
And Ankit, don't forget, today's webinar is special. We're not doing it alone. We're doing it with Indian Financial Forum, right? We have a strong community here talking about finance. And then what we want to do is we want to infuse finance with a few right decisions. I think some people have rightly posted questions which says that what are these quick takeaways, quick wins that they can take back home when it relates to financial data. And I think all three of us, and rather Sandeep and you, are the best people to answer these questions. Okay, so the agenda for the conversation today is we go through DPDPA, we understand what is this financial data. Deep down, we think about more data management. Privacy is not the general regulation that everybody talks about. I love जब भी मैं कहीं जाता हूँ, right? So लोग मेरे से बोलते हैं ये बात कि privacy, another regulation has passed. Everybody says, everybody thinks like that. So it's not another regulation actually. It's something interesting. This time a regulation has been passed for you, for your human right. So privacy as a law has been passed to give you a human right. So do not read this as another regulation. Because when you start reading this as another regulation, you forget that you are actually doing your job to make sure that the customer, who is a human being, is going to use your platform and his data is going to run inside, and you will also be that customer down the line if your company becomes big enough. Let's not think about
Right.
it as another regulation, right? That's where we should start. Okay, perfect. So, Sandeep, what is DPDPA's financial data sets?
So, as we all know, let's give a very short description of the DPDPA, which actually, when you look at the scope, it actually focuses on digital personal data and the personal data which is digitalized. Like when you obtain it offline and then make a digital copy out of it, then it becomes subject to the act. So when we look at the financial data specifically, in light of DPDPA, we have to focus on the identifiability of the data. So it should not be independent from, let's say, some transaction statement or balance sheet or cash flow statement or whatever records you have just mentioned here. It should be relatable to an identifiable individual. As long as that connection is established, only in that circumstance, DPDPA will be attracted. Otherwise, financial data, looking at it independently without any identifiability element within it, that I don't think that will be subject to DPDPA. But if it helps you identify a person, and if you are able to access his financial records, whatever records you've just mentioned here, if you can establish that connection, then DPDPA as well as other financial regulations will come into play.
Ankit, would you like to add on to this?
In line with Sandeep's inputs, that the DPDPA essentially applies to anything and everything which is related to identifying an individual. So if you are not able to identify an individual with the help of a particular piece of information, then definitely it's not in scope. But however, most of the financial data would definitely point to a particular individual or a particular entity. Other than the DPDPA Act, there are regulations which are governing these financial data. The financial industry in itself is a regulated industry. And then we have this Privacy Act, which is to enable and to ensure that we remain sensitive to the privacy of these individuals as well. Add on to what Akash mentioned, that we do not take it up as just an act. I'd like to explain this with the help of an analogy, that we have an act, we have a criminal procedure against murder, but we don't do it not because of the regulation, but because we are sensitive to the human rights or human life. And similarly, this Privacy Act is probably to introduce that sensitivity within the Indian ecosystem to ensure that we respect the privacy of the individuals and do not use or misuse that information without a lawful business purpose, right? So from DPDPA perspective, financial data is very well covered, but till the time you are able to identify with that particular financial information.
How do we get quick wins, right? Let's say we are doing this webinar right now. From today, since everybody here is on the webinar, Ankit and Sandeep, right? Whoever wants to take this up can, go ahead. What are these quick wins that people can do from this webinar to, let's say, next 1 month, 2 months? So what are these things that they can do? Yeah.
I'll just take that up, and I would obviously request Sandeep to add on. The quick wins for any privacy compliance, in my view, is to understand, like Akash also mentioned in the initial minutes of the meeting, that you should know the data that you're dealing with, right? You should have a data lake or an understanding of your information which is flowing within your ecosystem. So first and foremost, you understand what kind of information your organization or you are dealing with, right? And once you identify that these are the different kinds of information that I have by performing data, PII inventory, or by creating personal information inventory, you would be able to understand the type of risk surface, okay, what you're dealing with, what volume of information you're dealing with. And once you identify that these are the information that you have in your ecosystem, you understand your obligation. If you're complying with a particular law, then you'll have to understand what role do you hold. right? Are you a data fiduciary? Are you a data processor? And in what cases, right? Once you understand that this is the information and my role here is as a data fiduciary, then you will be able to comply with the regulatory requirements, be it getting consent from the users, be it performing regular assessments, be it performing audits, etc. Right? You can make changes to your systems post performing an assessment of your organization vis-a-vis to the regulatory requirements. That way, you'll be able to get the understanding of what are the issues that you have, and then go ahead and start fixing each of them one by one.
Like Ankit said, most of that applies to data fiduciaries. But when you look at the list that is given here, the last 3 points, that is appointing DPO, conducting privacy impact assessments, preparing for data audits, these are specifically prescribed for significant data fiduciary. And when you look at the kind of data fintech institutions or other financial institutions hold, it is highly likely that though financial data will be considered sensitive when they will be classified as significant data fiduciaries. So they will automatically have these obligations to perform. So when we look at the other wins, it's basically, since it's already a regulated sector, you also, the rights that we have are very much in addition to what are given under other financial regulations. Like if you are you can directly have a approach a grievance redressal officer or mechanism that is that is in an organization, get your data rectified, updated as in when you want. You can have it erased. So even if you want you want to withdraw your consent for the processing of one particular data set of yours, you can do that in an easily prescribed manner. So in addition to that, there is also a very important requirement that fintech institutions have to follow. Like Ankit mentioned, it is necessary that there should be very adequate technical and organizational safeguards to be put in. So when we look at in light of the processing principles, right? Let's take let me simplify this. So when you have a Paytm account, when you open it, you can directly view your wallet and how much money you have. But let's say there is an additional safeguard. Let's say that is masked. Your whatever amount you are having in the wallet is masked. In that case, to view how much ever amount you have, there should be some additional safeguard. Let's say there should be some sort of additional password that you have, or any other safeguard that can help you access the amount or wallet you have, your wallet on Paytm. So these kind of I would say technical specifications or measures, if they are taken, this will help the organizations achieve privacy compliance at a large scale, and they can also inspire the confidence of many users in terms of privacy, data protection. So that's
Right,
my
Sandeep.
key take
Thank,
here.
thank you, Sandeep. I think, and thank you, Ankit. I think that they're great points. I would like to kind of, also summarize both of you a bit of it. I know you have covered a huge concept here. So let's say I am giving somebody a loan, right? Loan will always be given on the basis of a contract, right? So then the data collection was done on basis of consent initially, right? Initially, when he was a prospect, when you're discussing with him, consent. The moment he's about to buy from you, right? And when he's buying from you, he's coming to your wallet, right? Then you can't just delete his data, right? Tomorrow, you cannot just give him a right that tomorrow somebody will come and he will say, I cannot do it, right? It's not possible. It's important to first of all think where you need a consent, finding the legal basis.
Just one question, and I was curious to is transactional information can be considered PII information? So yes, a lot of the transaction information do have PIIs. Some of it starting from the name of the merchant, right? Then you have TIDs. These TIDs are something which are issued by the banks. So the banks essentially to identify you as a merchant and connect your account, your savings account, and identify your current account. In that terms, they issue TIDs. Using those TIDs, you can only perform your sales. So a lot of merchants who are individuals, who are not organizations, they do get their TIDs, and their TIDs are mentioned as part of the transactions. And therefore, these transaction records become important from a privacy standpoint. Not only that, there are different RBI regulations, which require us to ensure that we retain those transaction logs, we implement certain guardrails around those transactions and the merchant information, which is very, very critical. And with this, we are just ensuring that we add an extra layer of privacy and be sensitive to the users' privacy.
Yeah, Ankit, and there is a follow-up question to that.
Please.
And I would like to also take it up, but probably I think if you take it up, that makes more sense. So, like, what should be considered? Should the RBI guideline be considered on top, or DPDPA should be considered on top? And
So, taking the precedence, right? So then RBI and the DPDPA. So the first and foremost is RBI looks at a very, very, very narrowed down set of information, right? So they only look at the information from a transaction on a business banking perspective. Say if you are a payment aggregator, if you are acting as a payment aggregator, then you have to follow these lines and you have to be implement these controls around your payment systems, right? That is why we have an act called PSS by RBI, right? However, DPDPA is looking at another aspect of it, which is privacy. So I doubt that there are, and in my view, I do not see any conflicts. Rather, they are adding on to it, and there are incremental obligation on the industries and the organization to actually secure the information which is coming from RBI, and the DPDPA is also saying secure the information. However, DPDPA is also adding certain other layers such as performing this privacy impact assessment, looking at the privacy part of it, because RBI and the other regulators have been looking at the security part of it all this while. Now, DPDPA brings the privacy aspect, and I have been, at least from the starting of my journey into privacy, I have been understanding that privacy cannot be there without security. So security is a driver for privacy. So please note that they are two sisters working together. Answering the second question and quickly about the retention schedule, which Akash just mentioned. Retention schedule has always been a requirement from RBI. You should know how long you're going to retain that particular information. Now, that particular information falls under the ambit of the payment systems. Only payment system. If it is employee data, RBI doesn't care. If it's payment system data, RBI cares. You should define the retention period. Now, the DPDPA says define a retention period. How will you define the retention period? First, identify the information and then define the retention period as your business need or your local laws. Right. So that's my take on the retention period schedule.
And Sandeep, you can take the next question for us, please. Is DPDPA currently enforced for financial institutions?
No, it hasn't been notified yet. So once it comes into effect, it will be applicable to all the institutions, including financial institution.
Yes.
I would also add some inputs to what just Ankit mentioned about the operation of RBI guidelines with the DPDPA. So, like you mentioned, there are no conflicts as such, but then RBI guidelines provide for many other requirements which complement DPDPA in the way that when we look at data processors or when we engage third-party service providers, RBI guidelines actually specifically mention what sort of requirements should be flowed down to such service providers when there is an outsourcing happening. And also they also mention data localization requirement, which is not there in DPDPA. So I see RBI guidelines or regulations that are promulgated by RBI more protective than DPDPA, but there are also other obligations that are in DPDPA which may not be in RBI guidelines or other financial sector regulation, but they complement each other, and of course they add another layer of protection, like you mentioned.
So what is the difference between a fiduciary and sensitive data fiduciary? Okay. So there are two types of organizations, right? Okay. So let me just explain two concepts and then we will move on, right? So any organization which decides what is going to happen with a data set is called a data fiduciary. Any organization that follows the data fiduciary's instructions to do data processing is called data processor. So two concepts, right? Fiduciary and processor. Fiduciary decides, processor follows, right? AWS is a processor, and every other organization that uses AWS to process something is, maybe a controller. If you go to Flipkart, buy something, Flipkart is controller. But if Flipkart hosts its services on, let's say, AWS, then AWS was the processor, right? Which Flipkart used AWS services to provide you services. Same goes for banks. Now, if you're a fiduciary, Then there are two types of fiduciaries: significant data fiduciaries, fiduciaries which are processing higher volumes of data, more sensitive data, more transactional data, they and more near for India's, India's infrastructure. So these fiduciaries will be called an SDF, right? The significant data fiduciary. And fiduciaries which are not SDF will be called a simple, like, which is a data fiduciary. Right? So two concepts, right? Fiduciary processor, then fiduciary significant data fiduciary. Yeah. Yeah, and I think there is one very important question here, right, which has been followed up, and I think I would open this for both of you as speakers. It's mentioned that financial data of defaulters can be processed without obtaining consent. However, Sandeep mentioned that there is a need to have consent. So if somebody is a defaulter, I think, can you just repeat this answer, Ankit? Yeah,
Right.
and Sandeep.
Yeah, sure. I was mentioning under DPDPA, like it is mentioned, there is no need to obtain consent. But if the regulations, right, whatever is applicable to that particular financial institutions, mandate obtaining consent, then that particular entity will be bound to follow that obligation. So that's what I meant.
Right. So from DPDPA perspective, something is exempted. See, DPDPA is right now a very new act, right? So there, please expect modifications. Please expect amendments to this act. Please expect certain more guidances. But then there are certain industry specific, which Sandeep was just trying to point out, that there are industry specific requirements that you have to follow anyway, right? So for example, if you are a credit bureau, if you need to follow the Credit Information Act, and it requires you to get the consent from the user. So if your organization, let's say, ideally while collecting the information, took a consent before, at the time of collection of the information, and in that particular consent, while taking that consent, you have mentioned that in case if you default the credit, or if you we have the right to reach out to you, and if you take that consent already, then there's no harm in reaching out to the defaulters, right? However, DPDPA here speaks about a general act. So be very clear that DPDPA, though is applicable on all, it's an umbrella act. But if you have a specific industry specific act, then you will have to comply with that, right? So if Credit Information Companies Act says that you have to take, and it is applicable on you, and if you have to take the being a credit bureau, you have to take the consent, you'll have to. If you're a bank, if you're a bank and you're not a credit bureau, you're a bank, and there are loan defaulters, then you don't need to take consent. As a bank, you don't have to take consent because your industry is out of that scope, right? So I hope this clears the difference
Yeah.
of industry specific and an umbrella act.
So international regulations, we have Basel. Basel 4, I think, is currently in Europe now, the fourth version of it. We have PDPA in Singapore. We have ISO 27001. We have PICI DSS. We have GDPR. Right? These are the other famous regulations, which also take care of personal data. See, guys, this is something that we wanted to have a conversation with. When you are a financial organization, right? You should classify the data into four forms, right? You have to classify the data, maybe public, internal, confidential, and restricted, right? So maybe Sandeep, would you like to kind of give us an insight on data classification that organizations can do? Yeah.
Yeah. So, like you have put on the slides, this is one way of classifying the data. The other way will be, classifying critical, sensitive, depending on the vulnerability. You have different classifications. But this part, when you make a public classification, you actually do not, it is generally available, which is in terms of risk score, which has to be protected, but then in relatively it has to be granted some level of protection less than what you would provide to other types of data like internal, confidential, and restricted. So in terms of internal is basically when, like you mentioned in one few minutes ago, that RBI could be data fiduciary for its employees, right? So when they decide the purposes of processing their employees' data, or let's say their customers' data in the context of data fiduciary. In that case, they will be able to they should classify this as internal documents, and they will decide on how long they should retain the data, what they should do with the data, everything. They will have complete control over the data. Of course, the rights will remain with the individuals whose data is being processed. In addition to that, confidential and restricted are basically more or less similar, which is to say that confidential information is more organization centric and restricted is again organization centric. Yeah, so I don't see much of a difference between those two, but depends on organization's practice and other requirements, the standards on how they classify these two, make these two data classifications.
Yeah, I think that kind of clarifies our basics as well. So, guys, covering a bit for other principles. So, the principles for privacy are lawfulness, fairness, transparency, limitations on purpose of collection, processing, storage, data minimization, making sure the minimum data is being processed. So, okay, so let's divide this, right? So, Ankit, why don't you take the rights of data principles in 2 minutes, right? What are the rights, human rights that people have? And then, Sandeep, why don't you take 2 minutes and tell us what are the duties of the data principle? Yeah, what do you guys?
So, from the rights of data principles, which are provided by the DPDPA, those are starting from right to access the information. Second is the right to correction and erasure of information. Third is right of grievance redressal. And the fourth one is right to nominate. So the first one, which is the right to access information about personal data, is mean that if you want to understand what all personal information an organization holds about you, right, you can reach out to the organization and request for access to that piece of information, right? Second is right to correction. If you have any issues with the integrity of the information in terms of that, let's say if your email ID is not correct, your name is not correct, your PAN is not correct, etc., then you can definitely reach out to the organization to request for right to correction. As well as you can reach out to the organization to request for erasure. Let's say if you are not part of the, you do not need to, you do not need to receive any marketing letters going forward. You do not want to be part of this, the processing activities to be, which are performed by the organization. You can definitely go ahead and ask under this act, which empowers you to reach out to the organization and ask for erasure of information. Right of grievance redressal is pretty obvious and pretty clear from the name of the right itself that if you have any grievances, if you would want to reach out to the board of the which is the DPA board, then in those cases, in both these cases, you can reach out to the organization as well as organization should provide you with the means of reaching out to the board through their privacy notice and how you can reach out to the board because I may not know how I can reach out to the board and showcase my grievances to the board, right? So the organization now in this case has an obligation to essentially provide the user with the information. Now, right to nominate, I could be I could be a differently enabled individual. I could not, I probably will not be able to exercise my own rights right now due to multiple factors, maybe age, maybe understanding, or maybe some kind of disability, right? Depending on it, the rights will still be with you. You can, on your behalf, nominate an individual to exercise those rights for you, to contest your rights and get you the justice in the court of law, right? So therefore, you have the right to nominate and say that this individual will be representing me to exercise my rights because I have so and so restrictions or I'm not able to exercise my right by my own. So this way, the act provides you with all the opportunities to ensure that your privacy posture is intact, right? You can contest, you can reach out to the organization, you can reach out to the board directly and raise your grievances and gives you a lot of power, which we did not have initially before the act.
Okay, so let me take up the duties of data principles, starting with legal compliance to exercise rights. So this basically means where data principles are expected to follow a particular, approach step by step, like it is mentioned in like one of the requirements is they cannot directly approach the court or anything. They cannot file a suit. They should first exhaust their opportunity before the organization's grievance redressal mechanism, and then they should move to the board, and only then they can appeal to the appellate board and then to the Supreme Court. So that is one of the requirements I can cite as an example under DPDPA as far as data principle is concerned on how to exercise their rights in compliance with the law. Secondly, if I can the impersonation of another person. Basically, it's self-explanatory. Like, you cannot impersonate yourself as someone else and then alter all the material details. Like, you cannot fabricate ID card of so as to impersonate and then provide it to the organization or data fiduciary to avail any benefits or services that they would provide to you. So that is one. And another one is about suppression of material information while providing any personal data. There could be some identification details or proof of your residence address or anything of that sort. If there is any discrepancy, let's say you want to avail loan and you are providing collateral, but which is subject to mortgage, these are some material information that you are bound to disclose, and you cannot alter, or you cannot do anything that will help you avoid disclosing such material information. And also, there are two other obligations, which is not to file any frivolous grievance or false complaint, basically to waste the time of data protection, grievance redressal mechanism, or the board. You should understand that whatever you have consented to, that's how the data is being processed. And you should, I think, as responsible citizens, we should understand what we have given the data for, what purposes the organizations are processing the data for. So everything, and then we should make a very rational decision if we have to file a complaint at all. So that is one of the things that we should be mindful of.
I find that. And yeah, guys, if you want to know more, you have YouTube at Tsaaro, you have IFF. If you want to know more about privacy, always there to have a conversation and discussion. And follow us for more, and we will have a lot more. I'm also running a podcast called Privacy Cast. So if you are interested in listening and have 15 minutes of time, just Google it. It's Privacy Cast, and you will find some interesting stuff for yourself. Have a nice day, guys, and thank you for the session. Thank you for
Thank you.
meeting. Have a nice
Thank
day.
you, everyone.
Bye.
Thank you.